cloud. Okay, welcome everybody to session 4 of our ICA 2020 post-conference, Digital Platform Regulation Beyond Transparency and Openness. I'm Fiona Martin from the University of Sydney, and I'm co-hosting this conference with Terry Flew, Nick Souza, and Rosalie Gillette from the Queensland University of Technology. And in this session, I'm joined by Stefanie Fuchsloch from the Institute for Journalism at TU Dortmund in Germany, Amélie Heldt from the Hans Brodau Institute in Germany, and Professor Josef Trappel from the University of Salzburg. Hi, everybody. Welcome.
Hi.
Now, we're going to start off with Stefanie. Stefanie, I'd love you to share your screen with us, and when you're ready, we'd love to hear what you've got to say.
All right, thank you very much. So just 1 second. So, all right. Thank you very much for the organization of the conference, and thanks to Fiona for the moderation. Today, I would like to present to you the step-based model to categorize new online media types and services. And I'd like to start with 3 reasons why such a model matters. And afterwards, I will present to you the model and show you why it could be useful. But first, a quick note. So the term digital intermediaries is used in a very broad way in the beginning of my presentation, but later on I will have a more precise definition. So just a few examples that this digital intermediaries term right now is a very broad term. But let's start with the 3 reasons. So first, the terms intermediary and platform are often used as synonyms in political and also in social debates, but they are not. And this is true from several different perspectives, such as starting with academia, as already Gillespie describes it, and I quote, platforms are not intermediaries, and also German legal scholars describe that as an uncertainty. And with a look to the European level, we can see also this challenge. So within their public consultations of the European Commission, many participants have expressed that there is a concern on a possible legal definition of online platforms and that there is a need to establish further categories of intermediary services. So in already adopted European legal acts, we can see this conceptual challenge of defining those services. And one example are these 2 directives. Both of them have been recently adopted and are services or deal with the services provided by digital intermediaries. So according to the Audiovisual Media Service Directive, they are platforms or video platforms are named as video sharing platform providers. And on the other side, the Copyright Directive, to which video platforms can be also applicable, defines them as online content sharing service providers. So both apply to video platforms and have similar criteria. So for example, giving the public access, the content is organized but not necessarily editorial, and the content is uploaded by its users. So what we see here is that 2 different terms are used to describe one and the same service. And as these services become more and more relevant, our traditional media systems still focus on basically of these 2 types. And this gives the problem of defining them properly. So on the one hand, we still have the periodically printed press, and on the other hand, we have the radio as the electromagnetic dissemination. So both of these media types address the general public to inform, entertain them, and educate. And as these new media types give rise to the challenge of defining them, there has been a broad public discussion whether these digital intermediaries, such as search engines or social networks, can be classified as media companies or either as host providers. So which leads us to the final point, that the news consumption is more and more online. So reason 1 illustrates the various definitions of the new services, whereas reason 2 shows that our media system is facing a great challenge of defining them, and reason 3 points to the importance to react as they are more and more important in our daily news consumption. So what are the current consequences? Because of these different concepts and regulations at different levels, this lead to, and I quote, a splinter net, as Flu and others point out. So balancing these different legal systems might fragment the way we interact online. So academia already offers a few approaches. For example, Van Dijk and others differentiate infrastructural and sectoral platforms. So infrastructural platforms are search engines, social networks, and sectoral platforms are operating or used in a specific area. And then we have Hellberger and others who differentiate actors by their gatekeeping function into infrastructural, so they are between different players in the information chain, and editorial gatekeepers who have the control over access and selection. And finally, for example, just one example, but many other researchers point out to that too, the need of more and precise criteria to describe the new hybrid technology and media companies. So, and this is where the step-based model comes into play. It helps to differentiate services of digital intermediaries and intends to provide a common ground for further discussions and debates on relevant criteria. So each step represents a further classification of services. And the perspective in the model is from the perspective of the user. So how does the user experience the service? This is similar like to Hellberger and others. They already also suggested a more user-centered approach. So from the first half of the model, it deals with the separation into intermediaries of other services and intermediaries which are relevant for the information dissemination process. So in this first half of the model, each step represents a higher relevance for the public information dissemination process. And of course, other criteria also play a role, such as the media system in this country, diversity, the independence, and so on. So, but let's start from the baseline of the model. So the model is based on all accessible sources on the web, such as blogs, social networks, websites, etc. And the first criteria is the kind of intermediary service. So either is it neutral and purely a technical transmission of data. Examples would be internet service providers or host providers are based on that step. Or is it about the transmission of content, such as texts, videos, or pictures? And it is categorized as a content-related infrastructure service. For example, e-papers, search engines, social networks, etc. would be in this step. And therefore, as they are more relevant to the information process, they go on the next step. And then the next step, the question is about the level is about the access to these communication services. So on the one hand, we have closed accesses, which would be, for example, individual communication providers, such as email clients or messengers, where it is possible to have an individual communication. And on the other side, we have free access, which means in principle, a user has the opportunity to access. So every user has the opportunity to access, even though a registration or a payment would be needed. And then on the next step, as this free access is very relevant, we are on the baseline of information fiduciaries. And according to Balkin, information fiduciaries are collecting and using our data of the users. But this ongoing data process is not, or at least not in total, transparent to the users. So that's why on this step, the intention of the business model is very relevant. So the questions are, does the business model contain partly the purpose to inform, educate, inform? Has it a publishing intention, a regularity of journalistic publication? And if it is a no to these intentions, we speak of information fiduciaries which are relevant, for example, to more which are more important to other sectors, such as, for example, trades, and therefore online marketplaces would be in that area. And if it is a yes, and then we are talking about content-related information fiduciaries. And so we are in the second part of the model. And now these criteria are more about the way the content is presented from a user's perspective. And in this second part, we see now the new selection criteria that are replacing or at least adding at the old forms. So the question now here is, does the service work as one product or as several sub-products? So is it one product and bundled by the producer? So this would be the example for e-papers by press companies or media libraries of broadcasters. Or is it bundled by third parties, means video on demand platforms that present different third-party content but appear as one platform for users? Or do we have like unbundled, which means that the content is from various producers, also user-generated content. So for this unbundled type, the examples are video sharing platforms, search engines, or social networks. And if we are talking that someone else is bundling the content, the question is the form of selection. So there are typical criteria for journalistic editorial distributors. For example, content diversity, regular publication, and the content is selected, edited, and contextualized. And then we have editorial, which means the decision is made on a day-to-day business. And for this selection, there is an editorial responsibility. This kind of is also defined in the AVMSD. And then we have the automated, which means that the decision-making process is totally automatically without any human interaction. So, and the AMSD, which I mentioned before, so the directive, the Audiovisual Media Service Directive, includes this criteria for the first time and means algorithms which are used for displaying, tagging, and sequencing content. And finally, on this step, there can be also a combination of both, so automated and editorial. And automated, for example, could be one algorithm, recommending algorithm based on my social signals. And on the other hand, there could be also an editorial board who decides what kind of relevant content in this specific team would be nice to see. So, and both of these variants could be displayed to the user equally. And now the next step is about the question, what kind of criteria are usually relevant for the automated system? And on the next step, and that's the final step, so various researchers point actually to the relevance of mapping journalistic criteria algorithmically. That's why we have here public value oriented. For example, Heldt and others refer to a concept of diversity by design, and also the expert group of the European Commission named ethical guidelines for artificial intelligence systems, such as respect for human autonomy, prevention of harm. And it could be a combination of, it could be a combination of my personal data and socially relevant and normatively desired criteria. So for example, my location data combined with local news. And then I think we all know that we have personalized, so the selection depends on my digital fingerprints, so on my profile, my activities, my interactivity, which has been also analyzed by McCosker. And more user autonomy would have two advantages. So on the one hand, the user would realize that there is a personalization, and on the other hand, users have kind of an opt-out possibility, for example, to decide whether they want personalization or not, or what kind of criteria shall be relevant. And finally, we have the individualized, which means that my social signals have no influence and I won't be tracked. So it's a kind of objective and neutral selection, like chronological. So, but this last stage already provides at least three options as technological development continued, there is no end to it. So because of virtual reality, augmented reality, these can be also new possibilities for news consumption. So this means the model is not at the end. So, but for now, the model shows the different kind of services and gives the option to further differentiate flexibly, both vertically and horizontally. So in the first step, it differs the relevant services regarding the public information and dissemination process, whereas the second step focuses on the selection and presentation of content. And in this stage, in this second stage, all have the potential to be equally relevant to the opinion forming process. And also here, there are other factors such as diversity by actors, diversity by opinions, or the range of coverage are also relevant. But we can see, like on European level, a lot of the directives have been already adopted and will be transposed into national law in the next years. So we can see also that traditional media law is expanding to include the new players as they are becoming more and more relevant. For example, the audiovisual directive is now also applicable for video sharing platforms and includes for the first time the organization of content by automatic means. So, but there's also still an ongoing reform process, such as the e-commerce directive, to which I guess Amélie will tell us later more about. So these are already adopted regulations and they draw attention to principles and parameters, such as more transparency about the parameters in regard to rankings, or more rights for researchers in regard to text and data mining, or keeping advertising and content separate on video platforms. So the model gives the opportunity to ask which principles and parameters are of relevant at which step of the model. And to decide this, the model allows a more precise look on the different services. And by involving different relevant actors at the respective steps, multi-stakeholder approaches might apply. So finally, I would like to emphasize that the model does not recommend any particular regulation intervention. Rather, it is intended to differentiate the services of digital intermediaries by a more precise criteria. So thank you very much for your attention. And so finally, any questions? So. Oh, I think you need to turn on your microphone.
Yes, I'm unmuting everybody now. Okay. There you go, Amélie. Yes. That was a great presentation, Stefanie. Thank you so much. Does anyone have any questions? Josef, yeah.
Sure. Thank you. Thank you, Stefanie, for this presentation. And I just, while listening to you, I did put myself into the shoes of a regulator. And I thought, wow, this world has become complicated. And if a regulator needs to contemplate first on which one of your 6 levels plus additional sub-levels any kind of intervention takes place, I would assume that they commit suicide. And we don't have any kind of regulation in the future. So don't you think that it might be necessary to simplify your step model, which is useful, to a level where regulators can intervene when it makes sense to cover more than just one step of your model in order to have an appropriate and working regulation environment?
Well, that's why the model is kind of 2 steps. I know it's complicated, so that was one of the last slides. So there are 6 steps in total because of the relevance and the different criteria. But actually, it's like a 2 kind of step-based model. So the first half is actually therefore just to separate like information service providers which are not relevant for the information dissemination process or even for the public opinion forming process. So, and the second part of it, so when it starts about content distribution, is it bundled or unbundled? The way they select, like editorial or automated, and then what kind of automation is used. I think that's the real relevant part for media law, actually. And that's when like the video sharing platforms are regulated in the AVMSD. So I think that part, so these three last steps, they are even more reported and important, and they are actually, it starts on European level that these are also regulated by them. And I think having a closer look on this second step would make it possible to differentiate more precise between these different services, because, like, of course, a video platform can have the same kind of services as others, but on the other hand, they are sometimes need to be more separated, or at least the terms needs to be the same in the same area. So, for example, like the copyright directive, online content sharing providers, and on the other hand, we have video platforms. I think having kind of more differentiated terms on the different services, that would help, I think, in the discussions and the debates around these new services. So that's the idea of the model, or like to start from that point. So we do have different services and different and these different services are important on a different level, and that's why we need to have a closer look on it. But of course, as a regulator, it's in the beginning very complicated, but maybe if we have like more a preciser look on the first part of the model, if it's needed, and then on the second part of the model, that might be helpful.
Amélie.
Yes, thank you very much. I thought that was a very interesting presentation, and I actually think it's maybe because I work in the same field, but or also as a legal scholar, but I didn't think it was really, I actually think it's very clear, and I think it gives a lot of clarity to the debate. We are currently working on a project for the German EU presidency, and we can tell from a lot of EU regulation that they sometimes fail to bring together, as you mentioned, terms are used differently, platforms are like named platforms without really thinking about their function in public communication. And I think this helps a lot to have a better understanding of the categories. Now, what I would be very interested in is how do you deal with the level of autonomy on the sixth step? And when you say it's personalized, is it something that you would, do you maybe go on, or what autonomy term would you work with, definition? And in general, if you use this model, is it to have a better, is it to have a clearer understanding, or do you see how it could be used maybe in other ways?
3 questions there.
Oh,
do you want to go with the first one, Stefanie?
Well, maybe one very quick note about where this model comes from. So I've started with all the digital single platform strategy has 3 pillars, and with 16, I think at least 16 different initiatives. So I started to check on all these documents, related documents, to check in which way platforms and intermediaries are used. As in these public consultations, many participants actually had like kind of concerns about the different definitions used. And so it was very, in a very broad way. So like platforms, infrastructure platforms, e-platform, and intermediary used also in very different ways, like one person to a platform as well. So we had like a very, very broad. So I've started from that point to get a more precise way of defining them, or like thinking about criteria. And on the 6th step, like the 6th step about the automated curator, that's actually like, I mean, that's a starting point. As I mentioned, it's now 3, but it will be soon, I guess, more. So it's it's possible to horizontally and also like vertically work more precise on it. So, but for now, I started from the point of public value orientated, because it's coming from more from the research area, as I've mentioned, various researchers like Fiona or von Nordheim working on it, and also the BBC. And personalized, I mean, we also can think about personalized and to separate it even more, or to differ personalized also more, because there are many different which kind of social signals play a more important role. So actually it's kind of, but then again, we are at the point of that this step-based model becomes more and more complicated with each further differentiation. And that's why I'm right now working with the term of a personalized automated curator, because it's well known, and like as Josef already mentioned, I mean, it's very complicated so far, but I think about like to differ it also a bit more and precise.
That's great. Look, thank you, Stefanie. We have to move on now so that everyone can have a little bit of time to talk too. Amélie, are you right to go?
Right. So I don't have a presentation. I hope that's okay. I wanted to.
We don't like PowerPoint very much anyway.
No, but yeah, I didn't think it would. I didn't need a PowerPoint presentation for this. Yeah. So,
okay, when you're ready.
Okay, good. Thanks. So my presentation is on the reform of the e-commerce directive in the EU, and perhaps you've heard it, but maybe not. I'd like to. So the regulation is not hasn't been adopted so far. So what I will show you today is maybe the reasons why a need to reform the directive has been identified, what's been done so far, the draft reports that have been published so far, and where this is heading. So it's really more of a status quo. There's nothing from the EU Commission yet, and I think it's more of a moment right now that, well, we'll see how it goes in the upcoming month. So so as you probably know, the e-commerce directive was adopted in 2001, and it substantially shaped the EU digital market. I will present two sections that are two provisions that are very important and very significant for the communication and media domain. So on the one hand, it's Article 15 that states that there's no general obligation for platforms or content hosters to monitor their users' content. And in Article 14, it states so under Article 14, member states shall ensure that service providers are not liable for the information stored by their users, either if they have no knowledge of the unlawfulness of the content, or if they're not, or if they act quickly after the content has been flagged or notified. They have been notified. So Article 14 was built the ground for many self-regulatory measures. The content hosting platforms our website were very free to have their own model. Many refer to it as the Section 230 model in the United States, so that content hosting websites are not seen as editors, but as pipes, so-called pipes. Now, this model was questioned a few years ago. I'd like to present two laws that were kind of started with that. because single member states went ahead and decided to tackle illegal or harmful online content. So first of all, we have the German NetzDG, the Network Enforcement Act, that many of you know probably. It's a law that, so its goal is to tackle hate speech. And under the NetzDG, social media platforms are obliged to offer their users a complaint tool that refers to sections in the German criminal law. They have to review the complaints promptly and to remove obviously unlawful content within 24 hours. They will have up to 7 days to decide on less clear cases, but they have, the fines were so high, are so high under the NetzDG that many decisions are reached within 24 hours. The law, so the NetzDG was really an explicit reaction of the German government to the lack of efficiency of self-regulatory initiatives. The former German Minister of Justice stated that there was he couldn't see any progress, and that was the reason why the German government had to adopt hard law and could no longer rely on soft law. So they were, so no new criminal laws were adopted for the NetzDG. Rather, it lists existing criminal laws such as insults, defamation, libel, incitement to violence, denial of the Holocaust, etc. There were two main fears after the adoption of this law. So one was the fear of overblocking because of the very high fines in the law. And the second was a fear of privatization of law because of law enforcement, because platforms were given the authority to decide whether content was obviously unlawful or not. A second example I just briefly want to mention is the French law on misinformation. So it's a law against information manipulation that was adopted after the last French elections, and it's aiming for better protection of the public debate against information manipulation in election times. So here again, already existing laws were kind of reactivated as a reaction to the spread of false facts and rumors during the elections in 2017. Here, it works in a way that flagged content will be removed until a court reaches a decision in an expedited procedure. So it's very similar to cases in press law. What is interesting is that it gives more, the instrument is more judicial review instead of enforcement by the platforms themselves. So with these two examples, we can see that, so there's not really a fragmentation in the EU regarding those, the problem itself, but there are different goals and priorities, as we can see, and subsequently different approaches. Now, there are also common initiatives such as the Code of Conduct Against Misinformation, the Database of Hashes, which is a cooperation between the EU and tech companies against harmful content. There are common approaches, but the idea behind the Digital Services Act, so the reform of the e-commerce directive, is to have a more aligned approach within the EU. So there's so far no official draft for the DSA, but there are draft reports from the European Parliament and that have been that are now with the Commission, and that sort of form a basis for the Commission to work out its report, its draft. The three committees that work on the DSA within the European Parliament are the Juri, the Libe, and the IMCO committees. Now, I would like to tell you what's in those reports, in those three reports. And then after that, summarize and have sort of an outlook of what could come from the Commission and what we're likely to expect. So the most important report, in my view, is the report from the URI rapporteur, so the Legal Affairs Committee. And I quote, they think that the Digital Services Act is so important because, I quote, content hosting platforms may determine what content is shown to their users and thereby profoundly influence the way we obtain and communicate information, to the point that content hosting platforms have de facto become public spaces in the digital sphere. So this shows the tone already of what we're looking at here. Digital platforms are no longer seen as a platform in a non-content related way, but in the URI report, it's about public opinion formation. It's about content as an information, and it's really something that is very much related to Article 10 of the European Convention of Human Rights, that is freedom of speech and information. Now, what is very interesting about this report is that it proposes that the Digital Services Act should include a regulation that establishes contractual rights as regards to content, with regards to content management. It should provide binding and uniform standards and procedures for content moderation and guarantee accessible and independent recourse to judicial redress. So in Article 5 to 11 of the proposal, we can find very detailed rules on the procedure of content moderation. It goes way beyond the rules regarding compliant mechanisms in the NetCG. It really looks at how is content moderated? So how can users flag? Who will revise or review the flagging? What actions are possible? What are the actions, the notification and the action standards for the user who published the content that is flagged or under revision. Article 12 of this proposal also states a stay up principle. So if there is no basis for removal, then content should stay up. There could be no removal without a solid base. Article 13 of the proposal mentions an independent dispute settlement. And that should include, and it also includes procedural rules for the independent dispute settlement. So the idea behind this is that content moderation litigation or cases should not overburden the judicial system of member states. And therefore there would be a sort of corporate bodies that would act as a sub-court system. They should not replace traditional courts, but they should support. This is very interesting when thinking of the corporate oversight bodies, such as the Facebook Oversight Board, that has been in the debate over the last month, and very recently with the members of the board published last week. What is interesting here is that this proposal mentions a regulation, because a regulation on the EU level is binding like national laws. So it may include room for national variations, but first it has general rules, same rules for all member states. And that expresses or shows the wish to harmonize content related rules. And it sort of builds on what has been done for the GDPR. That's a European standard, that's what we stand for, and that should be in common for the whole European Union. The report spells out other ideas quite precisely. So, for example, that content moderation, that any final decision on content moderation should be reached by an independent judiciary and not a private commercial entity. It also recommends the establishment of a European agency that would be tasked with monitoring and enforcing compliance with all the matters regarding content management and algorithm and use of algorithm for automated content curation. It also suggests that the platforms that are in the scope of application of the DSA should submit a transparency report, at least for those that would be in the scope of application of this proposed regulation on content moderation. Now, second, we have the report by the IMCO committee, and that is basically, I mean, they all go in the same direction. Here again, we have concrete legislative measures, including a notice and action mechanism. It also stresses that we have to maintain the safeguards from the legal liability regime of the e-commerce directive. The importance of platforms, of governance of platforms, considering their role in the public debate and the way and the access to information in the digital sphere. I'd say the IMCO report proposes gives a more comprehensive approach of the directive's revision, and definitely stresses the high level of consumer protection, but a more market-based approach than the URI committee report. Now, the LIBE report is the last report that was published. I'd say that in general, it has the same ideas than the previous two. It also warns that automated tools are not sophisticated enough to take contextualization in account, and therefore we have to look at the pitfalls we have to be very vigilant about freedom of expression. It also supports the creation of an independent EU body that would monitor all of this and that would exercise effective oversight. I'd say that the LIBE report actually goes very much into in the direction of the debate that we had last year regarding the copyright directive, so that we need access to information and monitoring and protecting third-party rights need to be balanced enough, and that we need a more aligned approach within the EU. So as a preliminary conclusion from those reports, I'd like to quote Patrick Beyer, an MEP of the Green Party, who said that the Digital Services Act could replace bad legislation in Germany and in France. Now, I'd like to question that, because I think that a lot of the rules that have been proposed and a lot of the ideas that are in those reports actually are very close to what has been done before. We have the principle of notice and action. We have the importance of the principle that there needs to be a human moderator, or at least an appeal that would allow a human to look over the decision, and limits for automated content removal. This, by the way, has been a problem in the last weeks due to the pandemic crisis, since many of the platforms could no longer have as much content moderators as previously. The reports also stress the importance of transparency and would like the DSA to have more transparency obligations regarding content curation. What is interesting is to think about how free really a choice is. So that relates to what Stefanie has said before on personalized content curation. And also, I'm interested in the question of how much are consumers actually interested in more autonomy when it comes to content platforms. Here we could possibly draw from the debates on the GDPR with regards to consent and autonomy, and from audience-related research for the question of default versus self-curated. So I think that would actually be a very good use case for the step-based approach. However, it is quite similar to what was already proposed by the NetzDG and what is already enforced in Germany. What is interesting also is that there are no changes for liability. A lot of people thought that the DSA or the reports would propose a change in the liability rules of Article 14 and 15 of the e-commerce directive, but neither reports have proposed that. However, there is this obligation to act promptly and to verify and react to notices more quickly. The overall goal really is to have a more aligned approach, but still to tackle important problems that have emerged or have become clearer over the last years. So what is known so far from the EU Commission? There's only a leaked note from DG Connect from April 2019 that mentioned the importance of a reform of the e-commerce directive. In general, they have also mentioned the same thing. It's a very brief note, only mentioning that we need more uniform rules for the removal of illegal content within the EU, and the authors also suggested maintaining the ban on general content monitoring under Article 15 of the e-commerce directive. What's to expect, or what has been said, heard from the Commission so far, is that it's really the Commission on the EU Commission under, especially under Margarete Vestager, is focused on redressing the competitive disparities between the dominant digital platforms and new market entrants. So that's the more market-based approach, or the more market-related part that is very important for the e-commerce or Digital Services Act. It recalls the objective to regulate online platform markets with strong networks effects, with the goal of securing the contestability of such markets as well as the improved regulatory oversight. So it's really a balance between and having a free market principle uphold and really the EU as a digital market, but still a market that needs more oversight and improved oversight. And so I'd like to conclude with really just the wording of those two regulatory acts. So we first had an e-commerce directive that was pretty broad. It was really looking at the EU as a marketplace, or as a market, and it had very important rules that really, well, the last 20 years were built on the rules of the e-commerce directive. And now the Digital Services Act is perhaps more consumer related or directed. Information and data are no longer perceived only as goods. I would say that the DSA could become a human rights infused regulation, and therefore serve as a very interesting example and perhaps standard on how we treat platforms and how we balance the rights of both consumers and service providers. Thank you very much.
Thank you. Thank you. Amélie, we have time for one quick question.
Right.
Now, let me just unmute everybody. Have you got a question there? We're going to go for one quick question. Stefanie, or yeah, Josef?
Very quick question actually is, Amélie. give us a time frame. When is the Digital Service Act going to be in force, or at least give us a time frame?
Right. So the reports have been delivered in 27, 24, 27 of April. So they're now with the Commission, and the Commission's draft is expected in the fall. The timeline is supposed to be end of 2020, but or at least to have a final draft that would go into the European Parliament but right now things have been slowed down due to the virus.
I just had a quick remark to make, Amélie. One of the interesting things about the DSA that's quite different from both the Net DZ and the French law, misinformation law, is the stipulations that are coming through about moderation, and particularly on review and appeal, I think. And that is quite interesting, because that one was something that Vera Jourova had recommended out of the Code of Conduct on legal speech trials, that, for example, people who had their content taken down needed to know why.
Exactly, yeah.
Yeah.
Can I ask also one very quick question? Well, my question would be about, like you've mentioned in the beginning, it's about that they are not editor, but more actually like pipes, like in the US. And later you mentioned like there's nothing going to happen in the liability area, such as it is in the e-commerce, like the notice and takedown practice. So have you any idea or any suggestions, any other approaches?
So first, thanks all for your questions. I think that what will change is really that so they call it a notice, and they call it notice and action. And I think that the provision, so Article 14 could be amended in the sense that it's no longer about knowledge, it's about not reacting promptly enough to user flagging, for example, to notices, and that this could be changed in a way that it would be more concrete, and in combination with this proposed regulation on content moderation that was just mentioned, and that is really the baseline of the URI report. It's a combination of the liability, the threshold for liability would be lowered, or it would be high, more difficult, more standards need to be respected in order or not liability guarantee. So, okay, this wasn't probably very clear. I don't think it's going to be notice and takedown, but I do think that it will be what is notice and action. The action would be so concrete that if they fail to respect that, the liability would be increased.
All right.
Yeah. Great. Amélie, thank you so much. We really appreciate everyone being here today. It's great actually that we can come together in this way, even if we can't have ICA on the Gold Coast, which we all wanted to do really. The Gold Coast is such a fabulous place to be. Josef, can we turn to you finally? When you're ready, the stage is yours.
Thank you very much, Fiona. Before I start, I just wanted to tell you that our fantastic video software prevents you from ringing the bell if you don't talk, even if you turn on your mic. So we didn't hear you ringing your bell.
Oh, damn.
That's the reason.
I was holding it very close.
Mm-hmm.
Well, it should actually be listening. It should be hearing the bell as well as, can you hear it now?
No, it's fine, because you are talking.
Yeah. Oh, right, okay. So I'm going to have to interrupt you verbally if you go over, so if you realise
No,
this.
you can wave at me.
Wave at me. I could do this. This is a nice radio thing.
Yeah. This means go on.
Oh, no. Okay.
In Europe, that means go on.
Oh, does it? Okay.
Yes.
This in radio terms used to mean wind it up, baby.
Yeah, it's I mean, with
okay.
English is fine, but verbal language is even more complicated across
Exactly.
cultures.
Exactly. All right, off you go. Tell us a little bit more about what you came here today to tell us.
Sure. Yeah, thank you very much. The last couple of weeks changed so much in our lives, and it did change also the meaning of words, which is interesting because whenever we talk about virus, 3 weeks ago we thought about our computers being affected by virus. Now it's something completely different. And actually, when I go and see my emails, I constantly get messages from my IT services saying that some of my emails are in quarantine, which again has changed meanings totally. So now I know how it feels like being an email in a quarantine. So this is how I'm feeling at the moment. Well, the COVID-19 pandemic actually restricted a lot of human rights, and we shouldn't forget about that. And these human rights and fundamental freedoms have also a bearing and a meaning on our communication practices. So some states have a state of emergency, they close borders, there are travel restrictions, as we know. That's why we are not in Australia now, and we're not going to be there in 10 days when the conference should have taken place. And at the same time, and as a consequence of that, these digital platforms we have been talking about this morning together, or during this session together, these digital platforms increased a lot in importance. So when we talk about homeschooling, home office, home teaching, distant learning, online banking, online shopping, all that is based, of course, on platforms. And I think that the pandemic might return at any time in the future again. So we are not safe about that. And in other words, that means that the importance these kind of platforms have gained over the last couple of weeks is going to stay with us. And in that respect, I think we need to increase our attention to define a solid legislation on these kind of platforms. And I think this gives us a very strong reference that our topic here, which is digital platform regulation, is of increasing importance. And this level of physical restrictions must not be, and I'm very serious on this, this must not be an excuse to restrict internet freedoms. So the internet freedom is going to be what we are going to experience over the next years together. And I think it's very important that we as communication scholars defend internet freedom in this post COVID-19 world. And my research actually deals exactly with that kind of internet freedom. And it has been done obviously before the crisis, before the pandemic crisis, but still I think it has a lot of meaning also for the post-COVID-19 times. What I'm talking about is a recommendation which came not from the European Union, but which came from the Council of Europe. And it was adopted in 2016, and it was called exactly Internet Freedom. And in this recommendation by the Council of Europe, which is a wider body than the EU, it has at the moment about 47 members, so it's a much larger transnational organization, and this Council of Europe requested its member states to make a survey about the state of the art of internet freedom in this very member state. And I was the one to do that actually for Austria. So I'm talking about this recommendation and how it is implemented in Austria. And it basically is, it has 4 or 5 indicators. And these 5 indicators we then have empirically checked were first an enabling environment for internet freedom. So this is what the Council of Europe requires, an enabling environment for internet freedom. And this basically is protection from cybercrime and digital literacy is a requirement to internet freedom. The second indicator is freedom of expression, which is very much related to Article 10 of the same organization, namely the Council of Europe, who has released the Article 10 of the Human Rights Convention. And this is, as you all know, divided into two elements. One is to impart, and the other one is to receive information. And any kind of restriction of this human right needs to be either proportionate or legitimate. Actually, it needs to be both. It needs to be proportionate and legitimate. And the third element in the freedom of expression is what we have heard about this today in this session already, which is overblocking, meaning that the freedom of expression has limits, and fake news, for example, again, has been with us, in particular during the COVID-19 pandemic, in an important amount, actually. Now, freedom of the media is the third element of freedom of expression, and the freedom of the media includes the protection of journalists against harassment. The third indicator is the right to freedom of assembly and association, which is also a human right. And this human right is extended also on digital platforms. The fourth indicator are personal data protection elements, meaning that under the umbrella of the human right of private and family life, this includes the right to rectify and erase information online. And the fifth and final indicator in the Council of Europe is the surveillance by authorities. And I think it needs to be extended to the surveillance also by digital companies. Now, if we apply this recommendation by the Council of Europe to the reality in Austria, what we did, first of all, was that we had first a legal analysis. We checked the Austrian legal system, whether this, the legal provisions comply with the requirements of that media freedom recommendation. And secondly, we did an empirical analysis by interviewing experts, both from the public sphere or the public institutions like ministries and regulators, and on the private side. So we did expert interviews with a number of organizations of NGOs who were looking, who are affected and whose expertise is to look into the media freedom. So out of that, we then provided a report, first to the Austrian government and later to the Council of Europe, which is published there and can be downloaded from their website. Now, what I'm going to give you briefly are the results of that research. And the first and maybe most important result is that there are no significant legal barriers in Austria to the access to the internet. So there is very little discrimination, be that in price, so that people can afford to be on the internet, or even in the sense of a digital divide along socio-demographic lines or along gender lines. So this seems to be of less importance in Austria. That has been important in the past, but it's actually is no longer. But what we found is that there is very little transparency in Austria about the traffic management of the ISPs. And that relates to some extent to what we have heard earlier today from Stefanie, that internet traffic management by the ISPs is one of your steps, and this is very important. And this is important with regard to net neutrality, of course, so that all these kind of information has the same right in the internet, but at the same time, it's also important for the fact that, for example, video software, as we use it here, and beyond, of course, like Netflix and YouTube, they are using so much of the spectrum available, so much of the bandwidth available, that we do have an important issue there, how we are going to construct in the future internet traffic, and that needs management, and that means if it needs management, it needs some kind of regulation. A second finding was that in Austria there are quite a few uncertainties remaining with regard to copyright holders. Again, this was one of the issues we talked about already. And if copyright holders exercise their rights, then it is a problem for the ISPs again, because they tend indeed to overblock in order to avoid the risk of being sued because of copyright issues. So there is a risk that overblocking keeps out of the public space, of the internet public space, quite a few information and content which could be there and which should be there. The third element we found is that the penal law and court rulings on the infringement of personality rights are to be considered quite well functioning in Austria. Although some of the police departments which are responsible for infringements, for example, of personality rights, tend to be undertrained and less competent than required. In other words, if people in Austria fall victim of being harassed in the internet, one of the formal locations to go actually to complain is a police department. And policemen normally are not trained to deal with that. And there have been complaints by quite a number of NGOs who say, okay, this is not a proper way of dealing with that kind of important infringements of human rights. Another point we identified was the right to receive information. So this is one of the elements of the freedom of expression human right. And this concerns, and maybe this is a typical Austrian issue, this concerns official documents, which are still kept secret in Austria. So there is nothing like a Freedom of Information Act in Austria. And this is very unusual even in the European membership in the European countries which are members of the European Union. So we need in Austria a Freedom of Information Act, and all these kind of all these kind of public information should be made available. Another one was data protection. So this is, of course, in Austria now governed by the GDPR, but still what is lacking apparently is a certain kind of awareness by the people. So we can say we don't have a legal problem here, but in fact we do have a problem because people are not aware of what happens to their data in the internet. And I think in particular for us as communication scholars, this is an important issue, that we do not forget that just having a strong legal basis like the GDPR does not erase the problem, because people do still give their data to organizations which should not use this data in a way they do. Now to sum up, and I've seen Fiona to show me that there are 5 minutes left only. To sum up, I think in a post-COVID-19 world, with increased importance of online services, communication policy studies should look in particular into the following points. One is traffic management to maintain net neutrality. The second one is to study the effects and the meanings of overblocking and overblocking mechanisms. I think this is an unsolved problem, not only in Austria. The third one is to define platform responsibilities, knowing that this is a very complicated issue, and we've heard about that earlier in this session. And finally, to contribute to the raising of awareness of data protection and privacy within our digital world, which, as I said at the very beginning, is becoming of much higher importance than it had been in the past, given this experience of our COVID-19 pandemic. Thank you very much for your attention.
Thanks so much. Josef, I thought it was interesting there that you mentioned the overblocking issue, because that's come up almost in all of the presentations. Amélie, Stefanie, did you want to ask Josef a question?
Do you want to start?
So thank you very much. Very interesting report, and I would be super interested to see it more in detail. Maybe on your last.
Hey,
good.
Maybe we can read it. I mean, it's in German, so it's for you.
Okay, great.
Josef, do you reckon you could put the link into the chat of this session, the group chat?
Which link?
Is there a link to the report? Is it online?
It's very well hidden in the Council of Europe's website. And I need to check the link, but I can make it available, of course.
That'd be great. And then I could stick it somehow we could make it available with the presentation. Sorry, Amélie.
No, so very interesting to hear that there is no Information Access Act or similar. That was a surprise. Also, I was so your last point on the awareness for data protection. I think it's a very interesting point, and I think it relates to all three of our presentations, because what we thought of as how do we consume or how do we access information, or how do we consume what type of media content do we want to consume in the sense of like, do we want to have it personalized or a default way? And that is something that is also mentioned in the DSA, for example, the whole part about content curation. So do you think, is there anything from your report that we should build on when it comes to the content curation on digital platforms, on social media platforms?
Yeah, thank you. Well, let me answer in a broader way. The recommendation I was talking about from 2016 required the member states to do reports like that in a repeated way, so that this becomes a monitoring instrument. So if media freedom is provided or not. So every couple of years, each member state should produce a report on that to monitor how things develop. And I checked again yesterday, actually, when preparing for this session, and I realized that Austria is still the only country who's prepared any report on this. But I think a monitoring instrument, looking at media freedom and all these associated concerns, would really be of a very high use, I think, because it's not only a legal issue, as you say, it's very much a practical issue as well. So how do people respond to that? What kind of access do people have? How do they exercise their rights? And if I remember this complicated step model we've heard earlier, how could a regular person understand at which level something has to be changed? So in that sense, I think the combination of having a legal response and having empirical data, how people react on that and how people make use of their freedom would be very useful. And that would imply, of course, all these kind of detailed questions I was talking about. So in that sense, I do still believe that this would be a good idea to have national reports about media freedom.
Can I ask just a quick question? Do you know if any of those are in preparation in other countries? Because you said only Austria has provided one so far.
No, I don't. But it's pretty easy to find out, because there is the CDMI, which is the steering committee on media and information society, and they would know actually. And each one of the member states, they have a member in the CDMI.
Thank you.
Well, so that was actually one of my questions, like compared your analysis to all the other member states, like the 47, but you've already said you're the only one who provided that so far. So yeah, I think that's also a very interesting point. So like these 5 differentiation regarding internet freedom. So, and in the beginning, you've mentioned like access has been a big problem or a bigger issue in Austria, but it is not anymore. Well, would you say like the others are more or less the same in the last few years, or is there also like kind of a change? And my second question, you've already mentioned like it would be useful to have that from all the member states, but what would be your recommendation to legislators, or is there already recommendations included in your part for Austria or for the Austrian legislators, or do you see it on a European level even more? Well, as Amélie mentioned, of course, the e-commerce directive is currently on the reforming process, so can you say one or two sentences to that?
Yeah, as scholars, of course, we ended our report in concluding in 10 recommendations. So we do recommend that to the Austrian government, what to do. Actually, as you in Germany certainly know, but maybe in Australia and the rest of the world, they don't know, there have been quite turbulent times in Austrian politics just before the crisis. So we had a so-called Ibiza video, and we had a change of governments. and the new government, well, the old government collapsed, so they were unable to look into details like information and communication policy. The new government was just in place when the corona pandemic erupted, so they have totally different things on the agenda. So all these kind of issues are blocked for a moment, and I think not only in Austria. So there are more important issues currently going on. Well, I think that, well, you asked for changes actually. Well, this was a report done in a snapshot. So we do not really have a history on that, but there is a long history in scientific writing about the digital divide. That's why we can say, okay, this has changed over time. And that's why we know that for the moment, for example, the gender gap is more or less disappearing or has disappeared already in Austria. While for the other issues, we do not have the history, so we can't say whether it's changing for good or the bad. But that's the beauty of a monitoring instrument. If you repeat that and if you do it again and again, then you can see a difference, or then you can see the trends. So unfortunately, no, there are no trends yet, but I hope that this will come back. And I think if we do that every couple of years, then we can see and we can identify trends.
Yeah.
Seeing this as the European panel, and that Europe has had so far the most sort of regulatory activism around platforms, I'd love to know from all of you how you feel the DSA might emerge as, and whether you think it will have an impact given the power of the sort of platforms we're using at the moment to hold up regulatory activism, to push back, to fight in court for years if necessary. Amélie, you might like to.
Should I?
Yeah.
Well, I do think so. I do think it's going to have a great impact, especially because I think it's going to at least have a more, at least when it comes to consumer rights and user rights, it's going to be, there's going to be a clear standard, and what you've also mentioned regarding the content moderation process rights, that's going to help a lot. I'm not sure about the European agency or something that would be a common body or council for all of these, or for all of the member states, because I think that there are already different councils and observatories that could also jump in and actually or take over those tasks. So I have mixed feelings, but I think that definitely the protecting or a stronger protection of user rights in a very clear way would also help having setting the right tone on all, across platforms, regardless of their market power, which I think is a good thing.
So liabilities and obligations sort of approach, yeah?
Well, yes, not only so the liability approach would be more concerning the harmful content or the illegal content, and I don't think that that's one of the questions is really like something that is illegal in Germany might not be illegal in France. So that's one of the problems, but I think that having a right to know why your content was removed, to be notified, and to have a sort of appeals process, or at least some sort of appeals right in that form, would be something that would be beneficial to all users, and that would not be sort of a detriment to the platforms. It's not going to hinder them in their models. So that, for example, is something that I think is a good way forward. Then there are other aspects that I think need a more that we need to know more about and need a more granular approach. That's not clear yet how that will be managed.
Josef, what do you think as a...
Well, well, if it comes to impacts of a European regulation of the future, and how that is received in other countries, if that was part of your question, then I think if we take as an example the GDPR, then I think it can make a difference, and the GDPR has indeed become the reference document or the reference legal status for quite a number of countries, and even some of the American scholars, they do refer to GDPR and say, okay, if we only had that. And they realize that in Australia and in other parts of the world, the GDPR has become the standard instrument on that issue. And in that respect, I do think that the Digital Service Act could become something similar to that. Also, the European regulatory building is a very complex one, and it's not that easy to just take out one element out of that, because this is so much related to others. As we heard about the e-commerce directive, for example, is very closely related to that. So it's more of a system in Europe where you cannot simply export an element of the system to a different environment. But still, the GDPR worked, and I could imagine that the Digital Service Act could work as well. But as we know, it's not yet there. It's not yet clear how it's going to end up. But I do think that Europe is of more concern about information society challenges than the Americans, certainly. And I think it's also more aware than some of the Middle East countries, for example. I do think that the Australian and the Oceanian legislators, they are looking very closely to Europe, how that develops. So in that sense, I do hope for a good impact, yes.
Stefanie, did you have any thoughts there?
So I actually just can add a few things, but of course, Josef and Amélie have already said quite a lot about it. So the GDPR, I would also say, I mean, it has quite a big influence, and it had it already in Germany when it was implemented or when it started. So I think people are more aware of the fact that there is kind of a data protection, or should be, but it's of course, I mean, it's of course still a working process of awareness, and still there are parts of the GDPR which will become in the future more relevant, for example, data portability, and also like in the other area, not just data protection, also like in the copyright, which is very different to others, other countries such as the US copyright. So in Germany, or not in Germany, but in the European Union, like the copyright directive has a few new rights, for example, for the researchers, the text and data mining, and also like the awareness in some other regulation that there should be like more awareness on the terms and conditions, and also on things like the ranking and what parameters are relevant. So I think we are in a starting point to think about what parameters are important within or for information society. So, but I still think we are in the beginning, but it's starting to have more influence and more awareness for everybody. I think at least also like the coronavirus shows it very clearly. Like, for example, in Germany, we are talking about that app and how balancing on the one hand like private rights or your personal data, and on the other hand like having such an app. So I think that's a kind of a discussion, and we're still in the beginning, but it's good so we have that discussion.
Well, look, I've got to say thank you to you all for being with us today. I'm really looking forward to the comments that people have from the rest of the conference. And yeah, looking forward to catching up with you face to face at some point in time.
Yes, that would be great.
Yeah, absolutely.
Yeah.
All right, thank you. And yeah, I'll let you know when this is going to be loaded. I'm just going to stop the recording.